extending this 3 years for pension fund contributions. And let me put end off on a good note. The good note is we have a bargaining council with 10,000 plus employees when the economy is really ticking, 300,000-400,000 members. We are the lowest, got the lowest fees in the country. I don't think there's any investment fees lower than 13. It is like, I think you can look at the audited finance statements. I think it's 17 basis points for 150 billion rand. We have our pensioners 150% funded. We're giving our pensioners a 13 and a 14 check this year, last year, and the year before. If you're having a 10,000 in pension or 100,000 pension, you are going to get extra 2 checks this year. So shortly, I think bargaining council are doing a hell of a good job, and congratulations to them. Yes, where there is corruption, I'm the first one to say, stand up and expose it. Let's not come to this forum and say, and let the police lock those people up who's stealing pension fund monies, because we can't allow pension fund monies to be stolen. Bargaining council or by corporates. Thank you.
Thank you very much, Omar. I don't think there was any questions per se, but thank you for the comments.
The main thing is to extend that 3 years, because I think we're going to fall foul. I mean, our fund also going to fall foul of the 3 years prescription. So maybe from your side, you want us to collect the money and we want to collect the money. But if there's a clever employer and he can drag us over 3 years and duck and dive for the 3 years, then we won't be able to collect the money after 3 years.
Yes, I am aware that it's already been raised that perhaps we go to Treasury to try and see, and just to clarify from our side, I know we've got a meeting with the OPFA next week, I think, if my calendar memory is correct, for us to discuss those issues as well and how to best go forward with the prescription issue around contribution specifically. So it is already being addressed, Omar.
And I'm happy to see that the transport section is also really doing something. Thank you.
Thank you so much. Mr. Essop, I see you are next. And if you wanted to reply to Ms. Trotter, you can do so. I think you are from MIPCO. Yes, Kia, can you unmute Mr. Adam Essop, please?
I have allowed his mic on our side. He can just unmute on his side.
Hi, good morning, everyone. Good afternoon, everyone. Thanks for giving me a chance, ma'am. So I think I'm not here to engage in debate with anyone. I think the one question that I'd really like from my colleagues, and interesting from Penny and maybe Omar, is that we have quite a strong collection process, but there comes a point where you have an amount owing and you can't recover that amount. So the question is, yes, you can spend legal fees up to an amount, and I think Linda spoke of, she quoted an amount of 140,000. But what happens with amounts where it's going to cost you more to try and collect that debt, or the debt is not collectible? What happens with that amount? And nowhere in the law is that taken into account. So does that just sit on the fund's books forever and a day? Because one thing we have to say is that if an employer deducted an amount from me and I'm owed the amount, I'll be spending Omar's money to collect my money. So where does the FSCA see this, where eventually there's an amount that's uncollectible? How is that dealt with? So I think that's the big thing that I'm grappling with, is that eventually you have an amount that you can't collect. And I come from a credit retail environment, and even the credit retailers who have fantastic collection mechanisms, at some point there's amounts that are not collectible. So how do we deal with that, colleagues?
Tando wants to respond, I'm assuming. Tando?
And I don't have an elaborate answer. I just thought I would mention that in the matter that the member was being sued, or was it the SAMO matter? One of the matters that are now slide. the amount that was owing, there was 15,000 rand. And that's high court litigation. And it gave us the decision that it did. I don't know if what is the definition of an uncollectible amount, especially in view of, as Pena was saying, I think there are people who retire with 4,000 rand. And that's all they have. Perhaps an extra. Yes, sir.
So my question is, how much in expenses would we have spent for that 15,000 rand? And who would, so in cases, you may have an employer who's absconded the country. He doesn't exist here anymore. You can't find him. You know, the sheriff goes and gets a null upon a return. Well, you know, there's all these scenarios. What happens then? And I'm asking, I don't have the answer, Tando. I'm just asking, what then?
No, I understand that there is false economics if you look at it from the numbers point of view. But I'm just talking about the principle that especially if it's a fund where members do not retire with a lot of fund credit. How do you, especially in addition to the fact that there is an obligation as interpreted by the courts that reasonable efforts to collect include litigation. So you might find that you're doing a certain selective litigation with an eye to the fees, but also to the prejudice of the members. I don't have the answer, Adam. I'm just putting it out there that in the cases that I have seen, especially with the municipal funds, that they really go after the last cent. And if you look at the costs that are involved, you find that they may outweigh the amount that is sought to be collected, but the principle of it is there's no price to it.
Adam, I think if I could just add to that as well, our prudential department also contact or had a discussion with us in relation to a liquidation where they were saying, but then give us the case number for this matter where you've got arrear contributions. And we actually had to debate that internally. So what Tando is saying is correct. We actually don't have the solution yet, but what I think needs to happen is the funds need to give us these practical issues, because remember, we sit on this side and say, this is what ideally should happen. And the law then gets, sort of drafted with that intent that this is what must happen. But ideally, and what we would wish to happen doesn't necessarily play out in practice as we would want. So one of the things that we definitely need to do is, this gives us a platform to bring up issues, but these won't be all of them. And we need you to give us those scenarios, because remember, we don't have the costs, we don't have the issues, we don't know how much is outstanding, and we don't want to deal with it on a case-by-case basis. So I'd really implore you, even going forward with any other matter, not just this, but bring it forward to us, because it gives us an opportunity to then see whether we must look at regulating or giving guidance on that matter. But to just say, what do we do in general? We won't have any other information and any other funds experiences to be able to give you, a well thought out response, in terms of policy as well, because it is a practical issue that you're facing, and it's certainly not just you, and it's important to address it. So I think we definitely need to go from there. But we've got auditors coming in next week in terms of presentations. So maybe that might be something that we can ask them in terms of how they are recording it, and then see whether we can take it from there. But I think that brings us to a close for the first part for today.
Takalani,
yes.
Sorry to interrupt you there. There's just two questions in the Q&A that haven't been answered yet. I'll just start with the first one from Ms. Ngwetjana, and it's directed to Tando. She's asking, where an employer did not deduct contributions when collecting the arrears, is the interest payable from the date that they did not deduct, or can it be from when we became aware that they were not deducting?
So can you just repeat the timelines?
Okay, so the question says where an employer did not deduct contributions when collecting the arrears, is the interest payable from the date that they did not deduct, or can it be from when we became aware that they were not deducting?
Sure. I don't know. I'm trying to think. I'm trying to relate it to the 7-day period during which the amount would have been collectible. The 7-day succeeding, the date during which the amount was payable. As to when you calculate it, okay, I honestly I'm at a loss. I don't know. Maybe Taki can assist me with that. If I'm not putting you on the spot, Taki, because I'm trying to resonate and I don't
No,
see it.
I'm quite sure that if you don't know, no, I'm just joking. Yeah, I think we'd have to just see whether we can give you an answer after we've thought about it, because it does raise a very good issue. Yeah, I don't know whether Gordon, did you want to answer the question, or Naheem? Naheem, you wanted to answer the question?
Yes. Is the question, let me just clarify, is the question when does late payment interest begin to run? Is that what the question is?
Yes, I think that's what she's that's what she's asking. So she's asking, is the interest payable from the date that they did not deduct, or can it be from when we became aware that they were not deducting contributions?
No,
Yes,
no.
so
Okay.
13A7 of the Act says interest at the rate prescribed shall be payable from the first day following the expiration of the period in respect of which such amounts were payable. So if you owed contributions for July, for example, then interest begins to run from the 1st of August. That's the way I understand it.
Is it not then if it's for July, is it not then from the 1st of July, Naeem? Because it's for the period that you owe. So if it was due for July, it should be the 1st of July.
No, it's 1st of August. It's that's how I read it. It says, because it says shall be payable from the first day following the expiration of the period in respect of which such amounts are payable. So it's the first day following the July period. So that would be the 1st of August.
Okay, so we interpret that on our side to be the expiry of the period that is being referred to is actually the 7th of the month for which they were due. So if it was that you needed to contribute for July, you would have had to do that by the 8th or the 7th of August. So you would actually owe for July from the 1st of July. So that expiry of the period, we've always intended that to be that it was due by the 7th. So once the 7th expires, you are actually in contravention, and then we count from there. So we'll have to look at it if you're, if the interpretation is going, because that's the first time I've heard it in that way. So we'll just have to look at how the wording should be, because the intention is that it would be from the 1st of July in the example that we're working on. Penny?
Thank you. So just because our period that we calculate LPI from, remember contributions are due on the 20th because of the historic thing with the bargaining council when the contributions come across. So LPI, if there's the late payment interest starts getting calculated on the date or the day after. So you'll see our calculations of LPI go from the 20th to the 20th of every month, because contributions come in on the 20th. If the contributions aren't received, late payment starts running the day after. So that's how we interpreted it. That's how we do it.
Yeah, and Penny, I think that's one of the things where I was mentioning earlier. I think in Tando's presentation, where there was a misalignment. I want to say was, because the conduct standard has cleared that up. between section 13A in terms of late payment interest and the regulations. And I think the regulations, and I'm just I'll clarify after, but I think the regulations actually lend themselves to the interpretation that I gave you now, that is the first. And the Act actually talks about your interpretation. And it was actually the first time in a long time, because we just took it for granted that that's what it meant. But we've now aligned it in the conduct standard so that the regulation speaks to, or the conduct standard speaks to what is in the Act, because we had that clarified with our regulatory framework division as well when they were drafting the conduct standard, to make sure that the Act speaks to the regulations or to the conduct standard properly. And I'm just now forgetting which one is actually there, but it's now aligned. Whichever one it is, it's now aligned.
That's why we're working on this in January to sort it out.
Yeah, no, we will have it sorted. I think Gordon has his hand up, then he puts it down. Then he has his hand up, then he puts it down. So I don't know if he really wants to ask something or if he's okay now. Gordon? Okay, he's got his hand up now, but he had his hand up before you, Omar. So I'm going to let him go and ask his question. Kia, can you unmute Gordon, please?
His mic has been allowed. He can unmute on his side.
Okay, so I think he's having some difficulty doing that. Omar, I do want us to close, so I don't know, if it's a question, comment, maybe we could have it.
No, it's not a big issue. I'm just going to say we agree with Naheem. That's why we do it. So space that you guys come back to say which one is the right one.
I will do that. I will definitely do that, and I will clarify so that we align it together with the conduct standard and the Act. Definitely.
Because we have a view contributions is paid in arrears, so maybe Naheem is right. But look here, neither you guys decide. Let us know.
Yeah, my reading of it seems to me, I may be wrong because you say the RFT guys have corrected it. It seems to me that the conduct standard and regulation 33 read the same way, whereas the Act reads differently. And on the version of the Act, it is the first day after the expiry of the period, not the end of the month, for the relevant contribution. It says the expiry of the period. It doesn't use the word month, whereas the conduct standard uses the word after the end of the month, in respect of which the contributions are owing. And Regulation 33 reads about the same. I think the odd one out is the Act if I look at it closely.
Yeah, so the regulation 33 specifically says the first following the month of which. So the regulation was actually not aligned with the Act. That I know specifically. So, but yeah, I think we can close and then have, I think we can then have this clarified for us, because it is actually important and it keeps coming up. So I wouldn't want us to have the confusion go on. But then we will have something for you and just maybe send out a quick note after this once we've clarified. Naheem?
Taki, I see Gordon's mic is on now. So
yes, I see it is. Gordon?
Yeah, no. Taki, you said I raised my hand and I wasn't saying anything. So one, I wanted to respond to what Naheem have said. But in practice, actually, our understanding is your interpretation that if it is for July contributions that are outstanding and the due date is by the 7th of the month, then we would go back to the 1st of July to actually charge that interest. That has always been my understanding, unless it can be interpreted somehow. But then the second one is just a question I wanted to pose to Penny with regards to, because they've got a nice model that is working for collection of contributions. And, one was just thinking to say, because now they've got that experience in terms of the costs. I heard everybody discussing about the costs, but I thought maybe she could share to say when they pursue these employers, who actually pays for those the litigation or litigation fees? Is it the members that have already been prejudiced by the employer not paying, or is it the fund? And if it is the fund, then what about the cross subsidization of those members that are whose affairs are in order, subsidizing those that whose contributions are due. Thank you.
Yeah, the costs. The costs are paid as part of our admin costs. So it's like we pay audit fees, and that's our biggest concern. So you're 100% right, the cross subsidization, because it's a fund cost. So the idea is now to try and reduce those costs, especially the attorneys' costs that attorneys used to do the PFA complaints, where you can't recover. In instances where we litigate in the High Court, we ordinarily, the fund doesn't like litigating. We won't litigate with a member in the High Court. We'd rather resolve. But in cases where employers usually take us to court, usually on reviews or where they're staying warrants, those costs, we usually get costs orders. Obviously, we try and recover, but we're trying to reduce the costs that we incur with attorneys in the PFA complaint prior to actually getting a cost order. So but it is a challenge because you're going to land up with a situation that you cross-subsidizing. The fees don't go to one employer, the fund pays for it as a whole.
Yeah, so in my view, and I'm going to close with that comment, we just need to be careful there because like Richard has used an example where, funds do not chase 15,000 and end up spending 140,000 because purely because other members are subsidizing that. So it's something that we need to take into consideration in arriving at whatever solution that we may come up with. So I just thought I should raise that, from where I'm sitting and based on my experience, and maybe that can be considered as well. Thank you.
Thank you so much, everyone. I think it's been a day of a lot of information that's been provided from experienced speakers in terms of their fields, and it was very important for us to start with the legislative framework and then go into some of the practical issues. We do have a presentation from Gyabetri later on the conduct standard in part 2 or 3 of the webinars. So please look out for that as well. But thank you very, very much for staying engaged throughout the morning and asking all of the questions that have brought about a lot of debate and a lot of conversation. That's exactly what we want. And we'll certainly note a lot of the key issues that have been brought up by the funds and see how we can progress those discussions beyond the webinar, because this is just, as I said before, laying the foundation for us to start the conversations, but it will certainly not be the end of it because we do need to get to some solutions. So if there is nothing else, absolutely nothing else, we are going to close now and we will see you next week. And thank you very much for your attendance.
Thank you. Bye.
Bye. Thank you.